Thanks everyone for joining. A few housekeeping notes before we get started. These slides will be available after the conference. You'll be able to download them from the Mobile First Conference website. So there's no need to take photos unless you want to see if your camera's working. But otherwise, you don't need to take photos. And during the question and answer period, that's right. But if you want to do like the little candle app and just wave it, that's fine. That's right. During the question and answer period, if you would speak to the microphone, that would be great so that everyone can hear. Otherwise, you'd have to have me reiterate your question and I may not quite get it right. And I'm not allowed to leave this platform. So we'll go ahead and get started. My name is Carl Spataro. I'm the Deputy General Counsel and Chief Privacy Officer at MobileIron. And for about the next 25, 30 minutes, we'll talk about employee privacy best practices or how you can enable trust in a mobile computing environment. So just a random question, is there anyone here that isn't carrying a mobile device with them? Yeah, it's pretty amazing. I mean, this is such a part of our life. And for those who have them, I'm guessing you probably have personal information on that device. So, you know, the fact that we're carrying this with us means this is a really relevant conversation in today's workplace. But the reality is, it's kind of complex and it's a tough environment for privacy and mobility because employee expectations are varied and subjective. And as we'll talk about in a little while, most employees don't actually trust employers with their personal data. There's also an interesting and complex legal landscape that continues to change and the technology continues to evolve as well. So navigating that mix can be a little bit challenging, but that's what I'm going to help you do today. Now, the bottom line is, I'm guessing that nobody here has like a handy-dandy card that tells them here's the 27 great things you need to do to maintain privacy in a mobile computing environment. What I want to present to you is just 4 basic best practices, because these are best practices you can keep in the top of your mind, and they're common sense, and they'll help you navigate this challenging environment. The first is just have a policy. The second is be precise. The third is be transparent. And the fourth is use available tools. So have a policy. Know exactly what you're trying to accomplish with the data that you are collecting and understand why you're collecting it. Be precise. Only collect what you need. And don't keep the data that you've collected any longer than you absolutely need it. The third is be transparent. Let your employees know what you're up to. And the fourth is use available tools. There are a variety of tools that can help you simplify the task of respecting privacy while managing mobility. Well, let's start with the problem. The problem is you don't really have a choice in the matter. If you're going to allow mobile devices to access any corporate data at all, you've got to manage those devices. You've got to manage them for a variety of reasons. You've got to protect your network against malicious apps. You've got to protect data that you've stored behind your firewall or in an encrypted cloud environment against malicious apps that may steal that data or may corrupt the data. You've got to be on the lookout for employee behavior that may not be the most respectable behavior. For example, downloading pirated movies from unauthorized websites. So in today's environment, you absolutely have to manage mobile devices if you're going to give them access to your networks. But that's where the problem comes in, because you have to, of course, in order to manage the device, and in order to properly manage applications and properly grant user access to important content, you're going to have to get access to some personal data. But as we'll talk about shortly, employees don't trust you with the data. And if you make a mistake, you're going to find yourself on the wrong end of a subpoena, a court order, or an investigation. But the good news is that these 4 best practices that I'll talk about at length, they apply to bridging both of these problems. A little bit about employee expectations, and some of you may be familiar with this, but in 2013 and again in 2015, we at MobileIron conducted a survey of 3,000 consumers in the US, the UK, and Germany. And what we found was that while 80% of employees are using their personal phones for work and for personal purposes, only 30% of them actually trust their employer. Now, that's kind of an interesting statistic because most employees provide their employers with a fair amount of information as a general matter of it being employed. You give your date of birth, you provide your salary information, you have various information about your family. So there's a lot of information that the employer owns, but yet when it comes to data on the device, employees feel really, really uncertain about what their employers are doing. And there's two reasons. One is, as I mentioned, we carry these things with us 24 hours a day, 7 days a week, and they are literally a record of our life on a regular basis. So there's a little more sensitivity to the fact that this is always on. And the second reason is employers just really don't understand how little information their employers actually get. The reality is employers can't see a lot of information that's on the device, and yet employees don't really know that. So part of the tools that we can give to you, and part of our whole mission as IT professionals, is to make sure we communicate reality to employees to help bridge that privacy gap. I'm going to pause just to mention for those that are latecomers, these slides are going to be available on the website, the Mobile First Web Conference, so you don't really have to take photos unless you want to test your camera. The other important issue when managing personal data is that respecting privacy is not an option. There are a variety of compliance and legal requirements out there, and there's no easy way to say this. It's kind of a mess. I was going to ask a trick question. Maybe I will ask it. So it's a trick question. Does anybody know what the data protection law in the United States is? Short answer is, like, there is no single law. There's this patchwork of laws, and it's really complicated. There's federal laws that are based upon the particular type of information that's being handled. States have their own laws that also apply to different information that's being handled. There's various agencies, including the FCC, the FTC. There's states' attorneys general, and then you've got compliance groups. So if you were to try to sit down and really go through every single law and regulation that might implicate privacy, you would never come to the end of it. And the European regime is even more complicated. There are separate data protection laws in each country. They're subject to interpretation and enforcement differently within each country. And then there's a legal jurisdiction there that the best thing to say is it's just really, really complicated. But that's why having 4 best practices is really helpful, because you don't really have to get too caught up in all those specifics. So let's talk about the first practice, which is have a policy. The bottom line is, you know what you're doing and know why. Now, I know a lot of folks here who aren't lawyers are going to say, well, that's a typical legal approach, just take a bunch of paper and throw it at a problem and hope it goes away. But when I talk about policy, I'm not really talking about a single document. In fact, I think it would be impossible for you to actually have a single policy document that would work across all potential mobile applications and mobile uses. Instead, I think you should think about it in 2 ways. One is, you definitely should have something outward-facing for your employees that gives them a sense of what your data handling practices are. But more importantly, when I talk about policy, I'm talking about a process. And the process is one in which you engage with all of the stakeholders and really get a sense of what you're trying to accomplish in managing mobility. So, for example, don't start with legal, don't start with HR. Start with the actual people that are doing operative work. Start with sales, start with marketing, start with product engineering and product management, and find out what they have in mind in terms of mobility. What applications do they think they're going to want to use? What type of data access do they believe they want to give their employees? And as you begin to pull together the various pieces of your mobility puzzle, then you can begin to identify and manage the risks. The risks are associated with the type of access that you're going to be giving employees. It's really that simple. So as you begin to identify what you're trying to accomplish and what type of access you're going to be giving employees, then you begin to identify how to mitigate those risks. A critical part of the process is also understanding and managing expectations, and this is as it relates to employees. One of the key aspects of any privacy law, and one of the key aspects of simply managing privacy, is understanding what employees are actually expecting with regard to whether or not a particular piece of information is going to be confidential or not. I'll give two contrasting examples. The first example is one in which an employee should reasonably have absolutely zero expectation of privacy. That example would involve an employee who maybe is a service employee, who's been given a locked down iPad or iPhone by his or her employer to do service work in a highly classified federal government installation. Now that employee has no expectation of privacy, and they should have no expectation of privacy. There's unlikely they have any legitimate reason to be posting selfies of themselves in front of a nuclear propulsion lab on Facebook. But in contrast, an employee would have a reasonable expectation of privacy, generally speaking, if they've brought their personal device into work. Let's say it's a sales rep. If I'm a sales rep and I have a single Apple iPhone that I've brought into work, and the only access I have to any corporate assets are Outlook, Salesforce, and maybe one or two marketing applications, then my expectation of privacy with respect to that information is that, sure, the emails I send for corporate purposes on my company-managed Outlook, I should have no expectation of privacy on that. But I sure am going to have a lot of expectation with respect to my personal photos and my personal text messages and all of the things that I'm doing that aren't work-related. So it's important to understand those expectations. The second principle is be precise. Identify what you need, limit your collection accordingly, use for the intended purpose, and delete what you no longer need. This practice is actually part of your policy implementation. You'll make a decision as your policy process about what data you need, but it's such an important practice that I feel it merits its own distinction, mostly because it's a practice that generally only is a problem when you fail to follow it. And this is where I get to bring out what every lawyer loves to see, which are lawsuits. Now, this is a complaint that was filed in May of last year, and it gives a great example of what not to do. So this case involves an employee named Arias and her employer named Intermex. So Arias was a sales rep who had started to work for the company Intermex, and her vice president of sales decided it was really important that she install this application on her mobile device called Zora. Now, Zora is a great application if you have service personnel and you need to keep track of where they're going and what they're doing, because what it does is it gives the employer 24-hour-a-day, 7-day access to all of the geographic location of that employee, including how fast they're driving. So if it's a service employee and you need to make sure that they're doing their job, when they're sent out on a call to go to a bank to fix a computer that might be broken, that they're not stopping by a pool hall to shoot a couple rounds of pool and drink a beer. So it might have valid use in a very limited context, but her employer decided he wanted to keep track of her 24 hours a day, 7 days a week, even though her job was sales. So when she confronted her employer about it, her employer made a really snide comment about the fact that he felt happy about the fact that he could tell how fast she was driving when she was doing activities in the evenings and on the weekends, and as far as he was concerned, she should have no expectation of privacy at all with respect to what she was doing in her personal life. So she took the application off of her phone and then, of course, got fired and then sued her employer for a variety of reasons, just a handful of which are invasion of privacy, intrusion into private affairs, retaliation in violation of the labor code, wrongful termination in violation of public policy, and unfair business practices. Needless to say, this case never made it to court because there was no way that the defendant could ever defend what they were doing. So the bottom line is, in short, just identify what you need to collect and don't collect anything that you don't need. This principle actually permeates all of the data regulations and all of the data privacy laws. The bottom line is, you can't make a mistake with data that you never touch. The third best practice is be transparent. This is also one of those principles that will go a long way towards bridging the privacy trust gap. Remember the trust gap we talked about at the beginning of this presentation. What we found was that, and here the pointer's sort of helpful, but anywhere from 25 to 40% of your employees, depending upon the country, would actually feel more comfortable about their employer having access to personal data if they really understood what the employer was doing with it. So there's a couple of ways that you can provide privacy notice to your employees. Before I get to that though, I do want to mention it's actually a critical part of any data protection law and most data protection regulations that you give notice to personnel if you're going to handle their private data before you start handling it. So it's very important to make sure your employees know what you're doing. So not only will it bridge the trust gap, but it also helps you comply with law. Now, there are various ways to do it. One really bad way to do it would be to like bury it on page 47 of a 125-page employee handbook. So that's probably not a great way to do it. You could also prepare a 1 or 2 page document that you distribute via traditional methods like via email or a wiki page or SharePoint. At MobileIron, we've created actually a visual privacy policy. And the privacy policy is part of the mobile device. It sits on the mobile at work application. And when the employee actually enrolls the device, they'll get to have a clear picture of what data you are collecting and why. And then at any time of the day or night, if the employee ever wonders what data is being collected, they can actually go to the mobile at work application, look in the settings, and see the visual privacy policy. Now this visual privacy policy is something that you create when you actually enroll the device based upon the decisions that you make. I want to mention one other aspect of this concept of notice, because these 4 practices, even though there are only 4 of them, they're related to each other. You can't like skip one and hope that by doing the other one you're okay. So for example, just because you've given notice of your privacy practice doesn't mean you're scot-free. If the practice that you're engaged in is not a good practice, then you're going to run into trouble, especially in the case of an employee controversy. So in the case of, well, to be more specific, in the case of an employee controversy, what the court will generally look at are 2 factors. The first was, did the employee have a reasonable expectation of privacy with respect to the information that's in controversy? So in the case that I was talking about here, this Arias case, you would look at the question like, does the employee have a reasonable expectation of privacy in what she's doing when she's not at work? And does, and even if the employer had given her a privacy notice, and actually in this case, the employer did put her on notice, I'm tracking your information 24 hours a day, 7 days a week. Of course, that came after she confronted her employer about it, but the employer now put her on notice. So, but that doesn't void the expectation of privacy, because the second component of any privacy inquiry and this is actually the component that trumps the first, was the employer's monitoring of that data, was the employer's collection and use of that personal data, was it reasonable, was it proportionate, and was it related to a legitimate business interest? So again, in this case of Arias, the reason why they would have had to settle this case is because that monitoring, it wasn't reasonable, it certainly wasn't proportionate, and there was no legitimate business interest in tracking an employee's whereabouts after work hours. So that just gets back to, it is important to have notice, but it's also important to remember to have a policy and to be precise in what you're monitoring. Which brings us to the last best practice, which is use available tools to empower an informed and confident workplace. Now, the good news is everyone here is a MobileIron customer, which means that you are doing the most important thing you can ever do when it comes to managing employee privacy in the mobile workforce, which is managing it. The worst thing you could ever do, and again, no one here does this, but the worst thing you could ever do would be to allow mobile devices on your network and not have those devices managed somehow. Because by doing that, you would be exposing personal data, unrelated to the mobile device, but personal data, say employee records, for example, that are sitting behind the firewall. You would be exposing those personal records to a device that was neither authenticated nor certified, and you couldn't be sure that the device didn't have a malicious app on it. So the most important tool is to use EMM. And one of the nice things about EMM tools is that they actually force you, to some extent, to engage in these other practices, because you can't actually set up a user profile with MobileIron's product unless you've given some thought, doesn't have to be a lot, but at least you have to give some thought as to what you're going to monitor, what applications you're going to allow to run on the device, what access that employee is allowed to have. So it forces you to have a policy, and it forces you to be precise. I also want to just highlight, earlier I talked about the visual privacy policy. So here's an example of the TRAS parent. I think that's a typo. Here's an example of a way to be transparent through an EMM tool. You can actually create a visual privacy policy that's available to your employees 24/7. But EMM isn't where the story ends. There are so many other tools that are available to you for little or no cost. MobileIron has MobileIron University, which is available, and that's a great way for you to make sure that your employees are trained and certified on using the product. In addition, our website has a ton of resources. We have blogs, webinars, white papers. If you're on our email list, you'll regularly get invited to a variety of presentations that talk about mobile security and mobile privacy. But there are also outside organizations that are definitely worth pursuing, and if anyone wants after the talk, I can give you these specifics. A few that I'm aware of that I like a lot are the International Association of Privacy Professionals, or IAPP, Trustee, which most of you may be familiar with. They certify privacy policies. Also, the FTC has some wonderful guidelines on privacy and security. It's actually one of the government agencies that's done a real good job of trying to make privacy and security simple for the rest of us. In addition, most of you have outside counsel. They probably have, especially with the changes that have gone on recently in European law, they probably have a ton of information that they can readily make available to you, ideally for free. They're usually going to be in the form of white papers. But most importantly, you have each other. One of the benefits of a forum like Mobile First Conference is that you get to meet and learn what your peers are doing. So I would encourage you to reach out to each other and find out what you're doing, because often the best way to figure out what's normal within your own industry is to talk to your peers. So with that, I will answer any questions that you have. Again, if you have questions, please come up to the microphone so we all can hear. No questions? All right, well, thank you very much. Again, any questions that you want to address, off the microphone, just please come on up and I'm happy to chat. Thank you.